Court required it to enjoin the city in a lawsuit. In February of this year, a summary judgment hearing was held, and the judge denied Phoenix's motion to summary judgment. October 3rd, the city had its motion for partial summary judgment heard. On October 16th, Judge Monica Benton issued the following order. The defendants assert that the plaintiffs have the burden of showing the existence of a dedication and that the intent to dedicate will not be presumed. They argue that the plat drawing itself is not clear, nor an unambiguous declaration of intent, because the final plat has language written on it by Derwin Rube that shows an area designated as a future road alignment. They also argue that if extrinsic evidence is required to show the intent from the plat language and markings, then two conflicting declarations of plaintiff's witness Derwin Rube eliminates the only available extrinsic evidence and thereby defeats an unambiguous dedication. The court disagrees that the conflicting Rube declarations presuppose summary judgment in defendant City of Woodinville's favor. The existence of conflicting declarations demonstrates the extrinsic evidence may not decide the question, and thus the writings on the plat document must be determined by the fact finder at trial. Accordingly, the city's motion for summary judgment is without merit. Now, therefore, it is hereby ordered: 1. Defendant City of Woodinville's motion for summary judgment is denied. 2. Plaintiff's motion for trial continuance is granted. 3. Mediation under Local Civil Rule 16 is required of all parties and must be completed no later than 28 days before trial. And 4. Not later than October 27, 2008, the parties shall submit the scheduled dates for depositions of any remaining witnesses. Thank you.
After being brought into the lawsuit, also made an attempt at summary judgment because it seemed the appropriate thing to do, that we have the opportunity that the other two parties also had. We felt very strongly that we had a very good case to make before the court. The court, for whatever reasons, has denied our motion. The case is apparently going to trial. We have a continuance that's not only resulting from a request for additional discovery by the Husos, but by the withdrawal of their counsel. And I tend to think that that was probably the greater reason for the continuance of anything else, to give the Husos an opportunity to obtain a new attorney. And, hopefully they do, so that we don't have further delay in the case. Apparently there was some disagreement between the attorney and the Husos as to how the case should be handled. At least that's what the attorney indicated to the court. So,
thank you, Mr. Rubstello. I think we have a question, Councilman Stecker.
I'm sorry, Mr. Rubstello, I wasn't clear. What's the status of the attorney for the plaintiff?
He has withdrawn. The court granted his motion to withdraw from the case.
So the court granted the attorney's request to
withdraw from
basically stop representing the plaintiff. Okay, thank you.
Speaking of the Huso 120-day continuance, I'd just like to make a clarification. There was a motion for continuance made by the Husos. but it did not coincide nor did it accompany the attorney's withdrawal request. The request for a continuance accompanied a motion to compel a very resistant city to attend depositions, some of who were requested serious dives. I'm sure that Mr. Rubstello would never misrepresent the facts. I'm sure he just got that mixed up.
I think all that paperwork came about the same day, if I recall. But in any event, what has happened is what has happened, and we'll see what goes from there.
Ms. Usual, would you come forward, please?
No one would want to make any assumptions as to why our attorney has withdrawn from the case. Thank you.
Thank you. Ms.